Well, first of all, I'm just relieved that the trial process, including sentencing, is finally over. This perhaps may go down as the longest trial that this office has ever mounted, and there are a lot of things that we really couldn't mention during the course of time while it was going on, but we are just relieved that it is now over. In respect of the sentencing, certainly the learned Chief Justice very carefully explained the basis for his sentences, and we certainly, given the provisions of the anti-gang legislation, we would certainly understand exactly why the sentences were as they were enunciated. We applaud the fact that in terms of leadership, that particular provision, we believe the sentencing was appropriate. If it had been more, we certainly wouldn't quarrel with that. This, of course, has to be looked at in the context that sentencing is quite often the most difficult function of any judge. But I believe that the learned Chief Justice clearly revealed his mind and showed that he has a thorough understanding of the particular material, evidentiary material. But coming from this, I did speak with senior members of my team in the matter, and I've also discussed it with Deputy Commissioner Fitz Bailey just this morning, and we all agreed that this would be an opportune time to make firm recommendations for the amendment to the anti-gang legislation, whereby there should be an increase in the maximum, or you would have mandatory minimum where appropriate, and that in one or two of the provisions, the judges should be able to go up to life imprisonment. First of all, in respect of leadership, leadership is under section 7(1)(b) of the Criminal Justice Suppression of Criminal Organization Act. And just for ease of reference, we call it the Anti-Gang Act. Now, the Anti-Gang Act was promulgated in 2014. We are now in 2023. There was an amendment in 2021, but it only dealt with some offenses, other offenses being created, but there was nothing done in respect of an amendment to the sentencing part of it. Now, when we look at the leadership provision, we believe what we have is a situation where, if convicted, I believe that the maximum that the court can sentence is 30 years. 30 years. Term not exceeding 30 years. Now, we believe, especially when one looks at the scenarios that played out in the evidence, that in 2023, the public interest would oblige us to ask for an amendment where you have life imprisonment as the maximum, and indeed a mandatory minimum to be served of not less than 25 years. In respect of being part of or participating in or facilitating serious offense, membership, which that is being part of a criminal organization, contrary to section 6(1)(a) of the Criminal Justice Suppression of Criminal Organizations Act. We believe that we need to have a lifting of the maximum, which is not exceeding 20 years. The maximum there is 20 years. we believe that that needs to be changed, and perhaps it could go up to not exceeding 40 years. We wouldn't necessarily suggest a mandatory minimum because given the fact, and as you can see in this case, that different persons, although they were only convicted of membership, call it that, but they had different roles. So if you leave it open-ended up to 40 years, then it gives the judge the flexibility to place the number of years depending on what it was that the person was doing. The Section 10 offenses, which deal with recruitment, inciting, we believe that here, aiding and abetting, if you look, you will see that at the section that the maximum is not exceeding 20 years. So you have knowingly aiding and abetting a criminal organization or becoming an accessory before or after the fact in carrying out serious offense. That's section 10, subsection 6. You have harboring or concealing participant in criminal organization. You have inciting or inducing a person to commit a serious offense or act of violence to promote or facilitate activities of the criminal organization. And I believe you have tampering. We believe that for all these offenses, the maximum should go up to life imprisonment because these are very, very serious, as you can see from the fact pattern or the evidence. And, you know, persons who perpetrate these particular offenses are literally driving blood into the veins of the structure, the skeletal structure, putting on the flesh on the bones and keeping the organization going. So we believe that we could do a justification here for these section 10 offenses for the maximum to be life. Here again, we would not put a mandatory minimum so that the court could have the flexibility, the flexibility to be able to, you know, depending on the actual roles played and assessing the roles in the context of the whole totality of the evidence, the judge would be able to better go up the scale as the justice of the situation deals with. You would appreciate, and perhaps members of the public would not be aware, that the case law coming from the Court of Appeal makes it almost mandatory for a sentencing judge to adopt a particular approach in sentencing, looking at aggravating factors, mitigating factors, and of course appointing a starting time. So if we go up to life or 40 years, depending on the offense, then the judge would be able to start much higher in terms of the starting point. And one could see that the Chief Justice went pretty high in the starting point. But you know, at the end of the day, which I hope the public understands as a matter of law, the sentencing judge must give full credit for the time already spent in custody. So if the person has spent 5 years or 6 years, any amount of years, it has to be subtracted from the particular figure. And that is law. But let me reiterate that we believe now that for facilitating, I think it is absolutely critical, and we'll be making those recommendations, that the sentencing for facilitating the commission of any particular offense must be pegged to what the sentencing would be for the particular offense once the Crown has been able to prove the commission of the offense. So for example, the murder. So for example, in this case, let me say one individual, and we know who that is, was convicted of 4 or 5 counts for facilitating murder. But you saw what the Chief Justice had to give him. And he had to, in a very Solomonic way, let me say, use the ability to have concurrent and consecutive to arrive at the 39.5. So what the public would know is that although we were able to prove that the offense of murder was indeed committed, under the anti-gang legislation, the sentencing judge was bound to go only up to a particular point. We are saying that in reality, because the sentence for murder would be life, then really and truly the sentencing judge should have been able to consider each of the counts up to life. So I think that would be very important. And we believe that it is really critical that in the present climate, this is why we believe that our cry for an amendment to increase the sentence should get the support of both sides of the political aisle, because it will be a good thing for the public interest. And the parliament, the police, the prosecuting authority, I dare say even the judiciary, we all have an obligation to do the right thing and to act in the public interest. The evidence was there for all to see. So I trust that you all will have been satisfied beyond a reasonable doubt that it will be a good call for an amendment. And I think I can say that both the police and the prosecuting authority, prosecution generally, that we certainly would support this call. And we will be seeking to put it in writing with the justification and submit to the Minister and Permanent Secretary of, I think the lead agency would be the Ministry of National Security, and we will copy the Minister of Justice and the Minister of Legal Affairs as an extension of courtesy, because I believe that coming from this case, it is an urgent priority, and that the amendment must be drafted and passed in fairly short order, because there will be other, and there are other gang cases coming down the pike.